Welcome to False Claims, Real Consequences.
This is False Claims, Real Consequences with Stephen Teller. Steve is a veteran employment and whistleblower attorney with over 2 decades of experience advising professionals through job transitions, retaliation claims, and severance negotiations. I'm Lisa Mosbey, and today we're shifting gears into the world of severance agreements. Welcome, Steve. Thank you so much for joining me today.
Thanks for having me.
You know, what's most important? And what's the most important thing that someone should know before signing a severance agreement?
I mean, when you sign a severance agreement, you're giving up your right to file a lawsuit and, do better than what they're giving you. Right? A severance agreement, they give you money, you promise not to sue them. So the fundamental question is that a fair value? And most of the time, the answer is yes. I mean, most severance agreements most companies, when they're separating and they offer a severance agreement, most of the time, they don't have a lot of risk. They're just trying to cap at their risk and not have to worry about whether their former employees will come back 2 years later and sue them, right? So it's not that they are worried about this individual suing them. It is that they generally like to get severance agreements from everyone so that they won't be sued later. Am I making sense? So most of the time, my point is, most of the time, companies are offering severance agreements in a neutral way just to, help the person transition out and then know that they're not going to get sued later. But some people have a discrimination claim or retaliation claim. It may be illegal what's happening. If that's true, then you need to know, is the value of my claim greater or less than the severance offer? And what else is going on in my life that would make it make sense to try to do better? In other words, if I'm just too busy, with my family, my obligations, the rest of my life, I don't need to go and get into a lawsuit and add another problem to life for a few $1,000s. Mm-hmm. But if now is the time when I'm unemployed because of the devastation of how I was treated, and I have, pursuing a lawsuit may make sense.
I think of it as an ending, kind of in a sense that they want closure. They want to complete their relationship with you in a lot of cases, but there are times when there's legal ramifications and you need to consider those. What are the most common traps hidden in these contracts, like non-disparagement or waiver of claims?
In my experience, there's very, very few traps, right? People get a severance agreement and they look at the legalese in there and they're like, I can't really fully understand it, especially this one paragraph about I'm waiving my rights. And it's got this strange language. I don't quite understand it. I better talk to a lawyer about it. And then what I'm doing is not talking about the content of the severance agreement so much as what happened before they gave you the severance agreement? Is there a discrimination or retaliation case there? Because the content of the severance agreement essentially says, I won't sue you. Now, there are a couple of other things that maybe they matter, but I haven't seen them come back in my career. Things like confidentiality clauses, non-disparagement agreements, terms that, no rehire clauses, right? I won't return to the employer I've sued. It's often in a severance agreement. So people don't seem to come to me and say, I got trapped by this. But more often just want to understand a little more clearly, like, what are the ramifications? Most of the time, the real question again is, am I getting fair value?
And so, Steve, how does Washington's Silenced No More Act change what's enforceable in these severance agreements?
Yeah, in the last few years, nationwide, and Washington kind of took a lead here 2 years ago. In the last few years, it's really kind of a crackdown on, let's not allow people to cover up the workplace misconduct as easily through severance agreements. Let's not allow gag orders in the same way. So Washington's Silence No More Act says that a severance agreement may not bar you from talking about illegal things. So if you complained about a wage and hour violation, sexual harassment, discrimination on the job, those kinds of things, you can still talk about those facts, even if the agreement says you won't disparage someone. because the non-disparagement can only now apply to things that are not illegal. My boss was a jerk. Okay, that might be covered by the non-disparagement clause, but my boss sexually harassed me. You get to say that. And then, most of the time, those kinds of comments like my boss is a jerk, that doesn't, if you write it on social media and leave it in writing and point it out to your old boss, you may get a letter from the employer saying you promised not to disparage anyone and you should stop and take that down. But if you're at you're at your friend's house and trash talking your old boss, go for it. It's not going to matter. Call me first before you rely on that advice. Let's check in. It's a little too broad, but most of the time those non-disparagement issues aren't so important for the things that people think about. The thing that matters is what's your old employer going to say about you to your new employer. That non-disparagement should go both ways.
What rights might someone be giving up without even realizing when they sign one of these severance agreements?
I think only the right to sue. I think that's the point.
Okay.
There are, at some level, again, this non-disparagement, maybe the ability to write a book about the dysfunctional environment that wasn't illegal. I suppose that's something they're giving up, right? Although I haven't seen that play out, and I think there's, often lots of ways out from under those things. So I don't think there's a lot of hidden rights in these.
They're not intended to trap someone or to hide things in them. They really are just an intention to close out that relationship, it sounds like.
To be sure they don't get sued later. That's why they're doing it.
So, Steve, can people negotiate these agreements even if they're not high-level executives?
Yeah, absolutely. A lot of the time when people contact me and they say, I'm having a problem at work, they're pushing me out, I'll talk about some of the elements they might say to HR to try to get a few more weeks, right? If there's a strong case, then, having a lawyer represent you makes sense, because when the lawyer writes a letter, the legal department at the employer will go, oh, that's a case. We should worry about that. But if it's a weak case, then maybe the employee is better off just raising this risk in a subtle way to HR and saying, if only I had a few more weeks of pay, I'd be able to move on. Right? So they don't, what's a good example? I've always felt a little awkward because I'm the oldest person in the workplace, but I understand that you wanted to, get some fresh blood. And so I appreciate that severance offer of 2 weeks of pay. However, it's probably going to take me a lot longer to find another job. I'm a single mom, and this is really causing a huge hardship. Do you think it would be possible to give me 6 weeks of severance instead?
It seems like if we can negotiate it, we may as well negotiate it simply because we could possibly walk away with more. And what are they going to do? Take away your severance?
Yeah, I've never seen that happen, right? You can always ask for more. Yes, it's true technically if you make a counteroffer or you reject an offer, that the offer can be withdrawn. So it's true technically. If you say, could I have more? They can say, well, we're not giving you anything now. However, they never do that, right? Literally in my career, it happened once, 33 years. I've never seen it, almost never seen it. So it's, what happens instead is if you say, I'd really like more, they might say, sorry, this is all we're going to do. You can take this. And that happens to me. If I write them a letter and I think I've got a good case and they point out why we're wrong, and they don't usually say, so too bad your client's severance offer is gone. They say, Mr. Teller, your client can still take that money if they want, but we're not paying any more. And sometimes that's the appropriate step.
So, Steve, what makes legal review especially important for workers over the age of 40 in light of some of the severance agreements that you've helped renegotiate successfully?
Well, age discrimination is a funny thing. It's one of our protected classes, right? We're all in multiple protected classes. I'm a white guy over 40. That's 3 protected classes. You can't discriminate against me on any of those bases in employment or public accommodations. But it's not really that common that we are aware that it's an age issue, right? It does happen, but so frequently people will say, well, I am 41, so I'm in the protected class and they're letting me go. And I'm like, that's not enough by itself,
Okay.
So I'm not seeing tons and tons of really egregious age discrimination cases. I think they do happen, but for the most part, I think really what ends up happening is more that the employers will more often discriminate on sort of unknown classes, right? When there's a change in the law, they won't say, "Oh, I didn't realize I'm not allowed to discriminate against gay people," right? Or I didn't realize that you have, 12 weeks of unpaid leave that I can't hold against you, right? Those are things that when those changes were made, employers often took a little while to figure it out. And then you'd get some really kind of overt violations.
I want to talk a little bit about what happens after severance is accepted. How does severance interact with things like Cobra insurance or that final paycheck, uh, the final paycheck rights in Washington state?
They're kind of parallel paths. I
Hmm.
haven't seen, the Cobra rights that's a funny name for the right to self-pay for your insurance after the end of your employment. And so you can continue to have the same insurance. That right is totally separate from issues about discrimination or otherwise. So whether you quit, whether they fire you, whether you sue them, whether you don't, the employer has the obligation to offer you the ability to continue your health care coverage. So they're kind of parallel. I don't even usually deal with that. Every once in a while, I used to have to write to the company and say, "Hey, what about the Cobra rights? You're not doing it fast enough. The insurance has lapsed." But lately, I don't even see that. I think they've just gotten better at making that happen.
And then how about that final paycheck, the rights in Washington state?
Yeah, same. Essentially, employers, HR policy tends to, have those kinds of things worked out pretty well, right? The check is going to follow X number of days after the separation or on the next regularly scheduled pay period. And yes, it does happen at times, especially small employers. You get sort of the master of the universe in charge of the small business, and they're just not going to do whatever they don't want to do. And sure, that can happen, but it's uncommon.
And then, Steve, what happens if someone refuses to sign or feels pressured to sign quickly? Do they lose everything?
Well, not agreeing to sign a severance agreement means that you have the right to sue them and they don't have to pay you anything.
Mhm.
So if you have a strong case, it's the appropriate step.
So, Steve, what should someone bring to their first legal consultation with you um, for a meaningful review of that severance?
Mostly, different lawyers are different. I mostly
Mhm.
work verbally, right? I rarely need to look at the documents, right? Your last performance evaluation, you can tell me what it says. I don't need to see it, right? I trust that my clients most of the time have things right. They should review their facts so that they can communicate them to me. Now, other lawyers will want all those performance reviews and all the emails that you think are proving things and all of that, and see it themselves, uh, maybe even before they talk to you about the case. It's just not my style. So, bring along, some of the things that do tend to be important are the specific wording for disability accommodation issues, right? I really want to see documents like the doctor's notes that um, limit activities at work, right? If we're going to enforce those, we need the details on that. Um, and then, if there's something that's really like, "Oh, you've got to see this email, lawyer." Okay, you know, obviously I can take a look at a few things, but I don't necessarily need to, in a consultation context, know more than, what you remember about the situation.
And before signing a severance agreement, should folks always check in with an attorney and have them review it?
I mean, I think it's a cost question, right? There's a due diligence. Um, Talking to a lawyer for an hour can cost $500, plus or minus. So if it's kind of a routine separation, I have no reason to think that I was mistreated. There's no reason to talk to a lawyer about it. Just take their money and go. Um, But if there's something nagging at you, like this wasn't fair how I was treated, there's something wrong here, especially if there's some hints about those exceptions to employment at will, those illegal motivations, let's talk. Let's see. It may be fairly easy to get a little more money, or it may be that, really the right next step is litigation. So just have to see how that fits into life.
When there's a concern, have a consultation. Makes complete sense to me.
I think so, if you can afford it. I mean, I often say to a lot of people call me from Amazon as they're being pushed out, and I say, look, it's gonna be worth it if it's affordable. If it's not affordable, let's talk. We'll figure out something I can do for you. But the consultation, the education, the consideration with an experienced person about what's going on in the workplace, I just think that's probably very educational. And most people at the end of the consultation will say, wow, this is great. Thanks a lot. So that's my criteria is it affordable? One thing to remember is that as we were talking, for example, about the Silence No More Act, right? There are limitations on what these severance agreements can do. So they can't gag you from talking about illegal motives in the workplace, discrimination, things like that. And they can't stop you from going to law enforcement generally. And you'll often see a paragraph, you usually see a paragraph now that says you can go to the EEOC, although you give up your right to get any money from them if you complain about discrimination there. You can go to the Securities and Exchange Commission and say, my company's breaking the law. You can file a False Claims Act case, usually, where there's fraud against the government, even though you signed a severance agreement. With the False Claims Act, let's be a little careful. Let's check in before you do that. But many rights to go report bad conduct remain even after you sign a severance agreement.
Before you sign away your rights, talk to someone who's reviewed hundreds of these contracts. Visit stellarlaw.com to schedule a confidential severance review and get the clarity you need to protect your career. Don't forget to like, subscribe, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.